Hello, my name is Manuel Melo, and today I'm going to be talking to you about a standard import contract from the Association of Food Industries. Before diving into the contract and the Association of Food Industries, I first want to tell you a little bit about myself and my background. Currently, I'm a second year student at the University of Miami School of Law. Prior to enrolling in law school, I spent about 8 to 10 years working in logistics. I helped transport pharmaceutical products, food products, technology products like cameras and sensors. And then I delved a little in compliance work for trade regulations. And I used to receive a lot of standard import contracts that I had to review and just kind of make sure that it met the needs of the companies I was working for at the time. So now, uh, a little bit about the Association of Food Industries. For the purposes of this video, the only information we really need to know is that they are an association that helps food companies, be it restaurants or any type of company that handles or imports food more specifically, and they help them by providing them with some general legal guidance around the importations processes and the regulations around those processes. And they've created this contract as a template that the members of their association can use when negotiating with a seller of food products that's located abroad. So that's how we ended up with this specific contract in our hands. The importance of import contracts is that they help set the expectations for both the seller and the buyer. And if there's additional parties like importer of records or exporters that are not associated with the seller, it could help set the expectations for them too. It also helps set a general risk level for both sides of the transaction by allocating who's going to be liable for certain losses, who's going to be at risk in certain types of situations or transactions that happen during import or the transportation of the product from point A to point B. But one thing I've noticed in my experience working with different companies in logistics is that buyers and sellers tend to rely on their relationships to carry them through these negotiations and to carry them through their relationships on these imports, which usually works. But when it doesn't, it tends to kind of degrade the relationship they have by just creating this conflict that they don't know how to resolve. And sometimes it can lead to just a breaking of the relationship, which might be detrimental to both sides. But if you have this contract in place, you're able to just kind of hit the ground running, be able to address many of the issues that you might see and that happen very often, and know which party is at risk, which party is responsible, and which party faces a liability, or just how you might go about resolving a dispute. So, moving on to the actual contract itself, I'm going to start and just go through it in order. I might skip a couple of sections of the contract that might not be as interesting or as important. Or I shouldn't say as important, every part of the contract is important, but it's just not the most interesting part of the contract to discuss in this video. So the first thing I noticed going through this contract is that it was created in 1991. The latest revision was in 2020, just 2 years ago. But as I went through the contract, and just skipping ahead a little bit, I did see some antiquated language. One section required a notice by telegram. That's probably not going to be the case, and I doubt that any parties that are using this contract are really sending telegrams in this day and age. But that just indicates really the age of this contract. And I mean, let's be honest, even in 1991, maybe telegrams were a little outdated at that time too. So the first section of the contract is just the general preamble. They've stripped away all of the language from the preamble that's not absolutely necessary. So all you see here is just the buyer and seller's names, addresses, the contract number, and the date. That's really all you need from the preamble. The rest arguably is there just for rather symbolic reasons or stylistic reasons. The second portion of this first page is the terms and conditions, which I thought that the labeling for this section was a little misleading. Not totally, but a little. When you start going through it, you realize the first section is going to be the product and description, which I don't know how that ties in with terms and conditions. I would have maybe separated this first section under terms and condition and labeled it something like product specification or something along those lines. But moving on, these first few fields are pretty self-explanatory. Product and description is just to know what to expect at the receipt of the products. You know, you can match up the contract and say, well, we're getting 20 pallets of bananas, and here's 20 pallets of bananas. The quantity, for the same reason, just general fact checking, and packaging, straightforward. Might even argue that it's not necessary to have that in the contract. Definitely in the import documents, but not here. But doesn't hurt to have more information here to just be able to fact check. Now, a very important section here is going to be the price. Unfortunately, in this contract, it's not specified what price you're going to be using, whether it's going to be the transaction price or if it's going to be the import price, which is going to have potentially going to have a couple additional prices over the transaction costs. Sometimes you might need to include the insurance cost or just the picking and handling costs, or just general additional costs might go in there for the calculation of customs fees. So it would have been nice if they could have specified which costs to put in there. Potentially this could lead to customs import violation on the side of the importer record, but that's a conversation for a whole other day. Moving on, the next section is the terms. I had a hard time distinguishing the terms from the shipment. I guess in this section, just because it's right after the product and description, I could easily have confused putting in the terms, just kind of what product is going to be arriving. But I guess that's just a sign of not having clear instructions of what's supposed to go in the terms. But after some thought, the only thing that came to me was putting something like Incoterms in there. Incoterms are just a quick guide, a 3-letter code to indicate when the ownership of the product transfers from the seller to the buyer. This has a lot of implications on who pays certain fees, accounting implications for if you're right at the end of your accounting period, if you took ownership of those products before your accounting period ended or after your accounting period ended, and how that's going to impact your financials. But again, that's a little bit outside of the scope of this conversation. Under shipment, I'm not quite sure what to put in there, but my gut feeling is that you likely include in there just some of the general transit information, probably what mode this is going to be moving on, whether it's going to be by air, by ocean, train, truck, what have you, maybe what type of service you're going to be using, something like a rush service, an expedited service, a general service, a delayed service. So I'm assuming just the different details of how that shipment is supposed to arrive to the buyer. But again, it would have been nice to have a little bit more detail as to how to fill this section out. Under insurance, again, more detail would have been great, but I'm sure you could probably put some reference to a different, well, or maybe just detail kind of what insurance you have, or whether you do or don't have insurance, but I'm sure it's going to be required. Most of these contracts require for some sort of insurance on the freight from the side of the buyer. And then remarks, that seems to be a general catch-all for any additional comments that either party wants to put in there. So now moving on to the actual meat of the contract. This first section is the terms and conditions, which is a slightly misleading title because this is more of an entire contract clause. An entire contract clause now is a clause you put in a contract to indicate that all the terms and conditions, all the duties and obligations, anything having to do with the contract is in the four corners, is within the four corners of the pages of this contract. So you're not going to be looking at any outside sources, no oral communications, no emails, no other contracts to figure out the details of this specific contract. Why they would label that terms and conditions, I'm not sure, but it's definitely bound to confuse a couple of readers like myself. The second section of interest is the liability section, which is the second paragraph of the real body of the contract. Here, it's a very aggressive risk shifting mechanism to shift the risk from the seller to the buyer. And this section kind of specifies that the seller is practically not at risk for any part of the import. But the interesting language here in the first sentence is unless otherwise specified. This comes at the end of the merchandise travels at the buyer's risk unless otherwise specified. That's very important because it allows the buyer to negotiate a different risk profile for this contract. It allows them to move some of the risk back to the seller and just agree on different terms, which could be hard to do depending on the leverage that they might not have, but at least they have this option and this language in here that does allow for a change in the risk profile to both parties. The second sentence of this liability section is really a force majeure clause. It talks about the items that you typically see in a force majeure, just kind of like natural disasters, government restrictions, things just outside of our control. And it specifies that the seller is not going to be a risk or is not going to take on any liability or responsibility if any of these enumerated events occur. I personally would have liked to see this clause as a standalone clause, just kind of highlighted so that it catches the buyer's attention. But nonetheless, I think liability should be enough of a labeling to indicate to a buyer that this is a very important section, and it's good that it's at the very beginning of really the meat of the contract. It's important section for me is the shipment section. It gives some definitions about the shipping speeds that a buyer might request from the seller. This is like the information that you're going to be filling out on page 1. It is a little weird that it comes after, the definitions come so far after that fillable section on page 1. For one, I get very impatient and I like to see this information right at the beginning. I want to know definitions. But as it stands, I don't think it's the worst. Because there's not many definitions, this is a very short contract. I think having it halfway through the contract is not really going to make this the worst contract out there. Interestingly enough, here it kind of talks about late delivery, which I think is a lot of information to fit in one section. First, you have definitions. Now you're moving on to responsibilities for late deliveries, and kind of it does indicate here that if delivery is going to be late, then the seller just has to notify the buyer of that delay, and they being the seller, gets an extension of 30 days to fulfill that delivery. One thing that's missing here is a timeline for when that notification has to be made from the seller to the buyer and how that notification is going to be made. There's no type of qualification here. There's nothing to indicate whether this has to be within a reasonable time, within a week. So what if the seller really doesn't tell the buyer of this delayed delivery until the day before it's supposed to be delivered, but maybe they knew about it for about a week? it does have some language that tries to address that by saying that the seller shall notify the buyer at once. But I think that that's very unclear. At once, it's not really indicating to me at once of in relation to what, to the seller finding out about the issue, to the seller having constructive knowledge of the delay. There's a lot of different variations of how this can be interpreted, and that's exactly what you want to avoid in contracts. So I think this could have been drafted a little bit better, but being a standard boilerplate contract, hopefully the parties that are using this are making their own adjustments as they see fit. Interestingly enough, it also, the same shipment section that goes on to allocate some liability at the end by specifying that if the shipment after that 30-day period is still delayed or it just does not arrive, then the buyer has a right to make a claim. And it finishes that off by stating that the seller has the sole authority or discretion to really allow or disallow that claim by the buyer for their extremely delayed shipment. Now, what's worrisome about that last section there is that there's no specification of the criteria for the seller allowing or disallowing a delayed shipment. In reality, I can't see a seller paying for a late shipment claim unless absolutely necessary. Maybe this is one of their bigger clients. Maybe it's a relationship they just don't want to harm. But on the average, just one-off transaction or maybe smaller clients, they're going to suffer from a clause like this, not having that protection in there of really allowing them to understand their risk profile as it relates to getting a late claim approved. And it really might affect some of the business decisions, because then if a smaller client that's affected by this might not know how to move forward with the uncertainty of when such a claim is even going to be decided on. That's something else that's missing. How long does the seller have to make a decision on such a claim? So overall, the shipment section, I think this is a poorly drafted section. It could have had better placement. It could have been more specific. As it stands, I think it's very ambiguous, and just I can see a lot of parties having disputes over this one section right here. Moving on, I'm gonna be skipping ahead a little bit and moving to the buyer's financial responsibility. This is again another just kind of a fail-safe for the seller, where it specifies what actions the seller can take to guarantee payment from the buyer. It specifies when payment is due, which is at the release of customs, and the release of customs being when the customs authorities releases this product into the United States. And that means that it's passed all of its inspections. Well, typically means that it's passed all of its inspections, and the product is now free to be picked up by the buyer or their agent, or delivered to the buyer on behalf of the seller. But this section really specifies that if there is some sort of situation that indicates that the buyer will not be paying for this shipment, or has not paid for the shipment after a period of, well, I believe it states here 10 days of notification of clearance from customs. Clearance from customs being the same thing as release from customs. So if the seller sees that the buyer has breached previous contracts with them, if the buyer has not paid within that specified period, or if the buyer's credit has deteriorated, which I'm going to come back to that, because again, it's not very clear what it means by the buyer's credit deteriorating, and I'll give you the direct quotation so we can break that down a little bit more. But under these three scenarios, the seller can take several actions to remedy the non-payment or the potential non-payment. Um, and these three actions are going to be obtaining a letter of credit from a bank to just kind of guarantee that payment. Once that letter of credit is received, then delivery will be made. To make shipments cash against documents. Cash against documents is basically just a withholding of the products until it's paid for by the buyer. So basically, the seller can hold on to the products, not release it to the buyer until the buyer pays up. Um, and the last one being, I think, the most extreme and probably gonna run into some legal battles over this, is that the seller can sell portions of the merchandise, um, which typically that is a resolution that you see enforcement by regulators for any import violations that extend the import clearance process over a period of 6 months. But that's outside of the scope of this contract. Um, but what's subject to a lot of debate here is that the contract states or specifies that the seller may continue to sell this merchandise even if it's branded with some sort of trademark of the buyers. Um, the specific IP rights here are a little bit outside of the scope of this contract, but it is interesting to see such a protective clause for the seller's payment. Um, the next section of interest to me is the arbitration clause here. It's pretty standard. You're gonna see this in a lot of B2B contracts, but an interesting part here is that it specifies that arbitration is the sole dispute resolution method for an issue arising out of payment to a broker or a commission payment. Um, I find this interesting because the third parties that are being addressed in this section are not parties to this contract. So an interesting thought is whether or not this arbitration clause is going to be enforceable, because the parties, again, are not parties to this contract. They're not bound by this contract, and they just there's no way this contract can be, um, that there's no way that they have an obligation under this contract. So the rest of the arbitration clause seems pretty alright to me. But before I move on from the buyer's financial responsibility section, I do just want to point out the antiquated language in this contract that I mentioned earlier. So here it states, after giving the buyer 10 days notice by cable or telegram. Clearly, not many people are communicating by cable or telegram these days, especially with the availability of email, postal service, or just any other type of communication method that's much more efficient than a cable or a telegram. I would hope, again, that parties using this template are updating the contract to be a little bit more modern and to include the technologies that they're actually using to communicate. But language like that could lead to some disputes between the parties, so it's to their interest to clear that up. The last section of interest to me was the responsibility of agent or broker. Here we're seeing the same issue as the arbitration clause. The contract is imposing responsibilities and obligations on an external party that is not associated with this contract, it's not a party to this contract. So this is not going to be enforceable. A contract cannot impose responsibilities on an external party, and I think this section really should be cut by almost every party that's going to be using this standard contract. There could again be a situation where the seller is the broker or they're associated in a way that might make the broker a party to this contract, but as it stands, that doesn't seem to be the case. It probably wouldn't be the case in most situations. So I think this is a very weak section. But overall, Um, my thoughts on the contract is that if if an acquaintance asks me if they should use this template, I would likely tell them not to. I think it's a pretty weak contract. It leaves a lot of ambiguities. The drafting is not excellent. It doesn't really address a lot of specific scenarios that are very common. And it just has antiquated technology stated in there, which is going to raise disputes. But some of the things that the contract did do well, I think it did a really good job just making the first page fillable, just kind of cutting away a lot of the unnecessary language for what might be just a quick transaction or a quick contract being used by an unsophisticated company that might not have the resources to really put together the most ironclad contract. Um, but overall, I think this contract needs a lot of improvement, and hopefully, the parties that are using it again, like I've mentioned a couple of times now, are just really going through this and just rewriting some of the language here, or hopefully their transactions are just not running to disputes where they need to pull out the contract. Um, but those are my thoughts on this standard import contract. Thank you for listening, and I hope everyone has a great day.